Welcome to the Going Global presentation with our experts, Mark Rhoads and Crystal Malik, who are going to give us the latest in the H1B processing for university graduates. Before we start, just a few opening remarks about Going Global. My name is Mary Ann Thompson, the president and founder of Going Global. You've been able to join us for this presentation thanks to your college or university subscribing to Going Global. Just a few comments: Going Global and all of our resources for 120 worldwide locations, and of special interest today, 47 cities here in the U.S. should be available to you, whether you're a student, staff, faculty member, or alumni, for 120 countries. But you should be able to access our resources both on and off campus. We have career guides, 16 million worldwide jobs and internships, and again, of special interest today, 6 million H1B visa application records going back to the year 2009, and very detailed instructions on how to successfully pursue an OPT opportunity. But today is all about H1Bs. The format of the conversation is our expert, Mark and Crystal, who I'll tell you a little bit more about momentarily, will provide you with the updated information on how to pursue an H-1B. As I said, it's high season to pursue an H-1B, and Mark and Crystal will tell you all about it. As we go along, you can be submitting questions into the chat box. We will answer as many as we can at the end of the presentation, and then you're invited to submit your questions that we don't have time for today to Mark and Crystal, who will then provide you with a response. That is really a special offer and opportunity from Going Global and our wonderful affiliation with our experts at the McCandlish Holton Law Firm. Let me tell you a little bit about Mark and Crystal. They work with companies and universities throughout the United States and have for decades successfully processed thousands of work visas and green card applications. Mark and Crystal frequently collaborate with college career services and other departments within the academic setting, providing valuable and updated insights regarding U.S. immigration procedures. Mark has been repeatedly recognized as one of the best lawyers in America for immigration law, while Crystal has been highlighted as one of the best lawyers in America, one to watch in the same immigration field. So it's a great honor for me and for all of us. There are over 500 of us on this conversation this afternoon. How exciting, and a true testimony to both the interest in the topic and the caliber and qualifications of our presenters this afternoon, Mark and Crystal. So with that, the presentation will be turned over to Mark and Crystal, and we'll answer as many questions as we can get to at the end of our discussion. Mark, off to you.
All right, thanks, Mary Ann. Pop it back to the previous slide, Crystal. So my name is Mark Rhoads. This is my law partner, Crystal Malik. And as Mary Ann said, we are immigration lawyers. What that means is we work with companies all over the United States, helping them process work visas and permanent resident green cards. Our office processes thousands and thousands of work visa and green card applications every single year. We work with companies all over the United States, large companies that have thousands and thousands of employees down to very small startups. And I can tell you that in working with companies all over the US, most employers, when you are out looking for a job after graduation, most employers have no idea how the immigration process works. So what we're going to try to do here in the next 45 minutes or so is to give you information about how you are able to transition from being an F1 student to getting a work visa and staying in the United States after graduation. The focus of the talk is going to be on H1B. I'm going to give a little bit of preliminary information on optional practical training, which is your first step to stay in the US. But I believe that in the next 45 minutes, we're going to be throwing so much information at you that you'll probably never remember most of it. So I think some of the most useful information is up on the screen right now, which is my contact information and Crystal's contact information. So if you are out in the job market and you have forgotten everything that you heard this afternoon, and if you have questions about the immigration process or about the H1B process, give us a call, send us an email. We're happy to answer your questions. If you are in a career service office and you have questions about the process, an employer talks to you or a student comes and talks to you and you can't remember what we discussed today, send us an email, give us a call. We're happy to answer your questions, and we do this for free. So this is a great free resource. I encourage you to hang on to our contact information. We field hundreds of inquiries every single year from career services offices, from employers, and from students all over the United States. So pop to the next slide. So in general, I can say I've been practicing immigration law for about 28 years, and I've been doing these kinds of presentations to university audiences just about that whole amount of time. And I can tell you that in my experience, the typical path that almost every international student will follow to stay and work in the United States is the path right up here on the screen. And that path to stay and work after graduation starts with getting what's called optional practical training, OPT. OPT is a little work card that will allow you to stay and work in the United States for up to 12 months after graduation. Every F1 student who graduates from a US university is eligible for 12 months of optional practical training. It allows you to work for any employer anywhere in the United States, doing any job, as long as the job is related to your degree program. And the great thing about OPT is that the employer doesn't have to do anything. All they have to do is decide they want to hire you, and as long as you have your optional practical training work card, you can go to work for that employer. The employer doesn't have to file any paperwork with the government. The employer doesn't have to pay any fees. So employers like the optional practical training as a first step for you to stay and work in the United States after graduation. If you're in a STEM degree program, science, technology, engineering, or math, you will get an additional 24 months for a total of 36 months of optional practical training work authorization in the United States. I don't want to belabor talking about optional practical training. I encourage you, when you are in the last semester of your degree program, that's when you can apply for your OPT work card. You should work with your international student office to apply for that optional practical training work card. You want that card to be in your hand by the time you graduate. You cannot go to work until you have the card. But once you get that card, you can then work anywhere in the US for any employer doing any job for up to 12 months. If you're in a STEM degree program, for an additional 24 months for a total of 36. While you're working for the employer using your optional practical training, you'll want to talk to the employer about the H1B. That is the second step for you to stay and work in the United States after graduation. Step one, get OPT. Step two, talk to the employer about H1B. H1B is the most common work visa in the United States. It will allow you to stay and work in the US for up to an additional 6 years of work authorization. And it's typically during the time that you're working using your H1B that individuals will then apply for a permanent resident green card. We're not going to spend time talking about permanent resident green card today. That is typically the third step in the process. You start with your optional practical training, then you go to the H1B, and then you pursue a permanent resident green card. And with that, I'm going to turn it over to Crystal, who is going to walk you through the ins and outs of pursuing the H1B.
So the things that you're going to have to really address with your employer, the things that they're going to really want to know about are, how much is this going to cost me? What is the timeline? What am I going to have to do and when? So the cost, the timing, the obligations, the responsibilities. They want to know what they're legally responsible for when they start sponsoring you. So as Mark said on the last slide, they have that optional practical training period of time, either that 12 or 36 months, where they have very little responsibility. But once we get into this H1B section, they have a lot more responsibility. At this point, they have to actually put some money into it and actually sponsor you. So we've already identified that H1B is the most common type of work visa. That's because this is the type of work visa that's for college graduates, people who have a bachelor's degree, who have a specialized bachelor's degree, and who have a job offer that requires that specialized bachelor's degree. When you're talking to the employer about sponsoring you, they are actually going to have to sponsor. They're going to have to offer a job that requires a degree. They're going to have to file applications with the U.S. Citizenship and Immigration Services. Those applications, those petitions are going to have to prove that the job requires an applicant that has a degree, the degree is related to the job, and that you hold the degree that they need for this job. At this point, the employer also has to agree that they're going to pay what's called a prevailing wage. The prevailing wage is the amount that an employer has to pay for a similarly situated employee in the exact location at the same skill level as the job that the employer is offering. And this is something that's publicly available. The government releases statistics on it every single year. And as immigration attorneys, we know where to go, look up that job, identify what that prevailing wage is, and to help the employer figure out what that prevailing wage is so that they can agree to pay it. At this stage of the process, they do have a lot of responsibilities. They have all of these responsibilities you saw above, but they don't have to prove that they can't find a U.S. worker. They don't have to advertise for U.S. workers and then figure out that they can't find one. At this point in the at this step of the process, they're able to just identify that you are the most qualified employee. They want to hire you and that you meet all of these requirements.
And let me just jump in real quickly, because one of the issues that comes up frequently is how closely related does the degree have to be to the job? And what I typically, I mean, when you say that the degree has to relate to the job, like, for example, if you have an accounting degree and you go to work as an accountant at an accounting firm, that's a great H1B. I love that kind of H1B because there is a close correlation between the degree that you have and the job that you are going to do. But let's say that you have an accounting degree and you decide you want to be a museum curator. Okay, so a museum curator probably requires a degree in order to do the job, but it doesn't require the kind of degree that you have. There's a disconnect between the duties of the job and your degree. And this is the single biggest reason that the Immigration Service denies H1Bs, is that when we submit the application, they look at the job duties, they look at the degree that the candidate has, and they say, I don't think that there's a close correlation between the job duties and the degree. And if they don't believe that there's a close correlation between the duties and the degree, they will deny the case. So what we do in our office frequently with H1B applicants is we tell them, okay, send me a bullet point listing of the job duties. And then I want the individual candidate, you, to go through your degree transcript and tell me the coursework that you took that relates to each of these duties. And if you can make a close correlation between the job duties and your degree transcript, you'll have a very strong H1B. If you can't make a close correlation, you might want to start looking for a different job, because this is the key to getting a successful H1B approved. Crystal?
And as Mark says, that's the biggest number of requests for evidence, where they ask us to supply more evidence to show that the two are related. And it's the biggest problem with denial. So at the front end, you want somebody to be taking a look at these requirements and making sure that you won't have that happen to you on the back end. So an H1B is, you can have H1B status initially. The initial allowed duration is 6 years. They do this in 3-year increments. So what your employer is going to do is they're going to request a 3-year amount of time. When they get within 6 months of the first 3 years ending, they'll request a second 3-year extension. When you have H1B, what happens is if you were inside the US when you applied for H1B, the US Citizenship and Immigration Services will change your status from whatever your status was before to H1B. They'll issue you an approval notice, and at the bottom of the approval notice, it'll have a brand new I-94. So if you're in the US, you know that an I-94 is the document that Customs and Border Protection gives you when you enter the US. So when you come in, say as an F1 student, they give you an I-94 that says that you're here in duration of status while you're being a student and while you're doing your optional practical training. When you get your H1B, they're going to give you an approval notice that has a new I-94 at the bottom of it that changes your status to H1B. It identifies who you're allowed to work for. It gives you the same I-94 number, but for an extended period of time, for that 3 years. When you're on H1B, you're only allowed to work for the employer that's identified on your H1B approval notice for the period of time that's identified. That petition will have described the exact job you're working. It'll have described where you're working. It'll have described your wage, and it'll have described how long and what they're paying you. It'll have all of that information inside it. Your scope of work authorization at that point is exactly what was in that petition. So if, let's say you were living in Virginia and you want to move to California, your employer is going to have to notify the Immigration Service of that change. Or let's say you get a big promotion and you started out at entry level and now you're managing other employees. That's another H1B change. Your employer would file a new H1B petition to notify the Immigration Service of that change. If you wanted to change employers, the new employer has to file a new petition for you describing that they'll now be your employer and providing all of that same information your prior employer provided, where you're going to be working, what you're going to be doing, how much you're going to be paid, and how you qualify for H1B. So every single time that you change jobs or get promoted or any of those things happen, anytime that a big change happens in your employment, the Immigration Service is going to get a new petition and they're going to make a decision making sure that your new employment also qualifies for H1B. One big upside to already having H1B and changing employers that you see at the bottom of your screen is that they have a portability provision where if you change employers, as soon as your new employer files a petition, you'll be able to go ahead and start working. You don't have to wait for an approval notice for that new employer.
And let me just say a couple of things back on the duration of the H1B. So as Crystal said, when you change employers, the new employer has to file a new H1B petition for you. But that doesn't give you a new 6 years. You get a total of 6 years, no matter how many employers you jump around to. So for example, let's say you graduate, you're working using OPT with employer A. Employer A files and gets you an H1B approval for 3 years. 1 year in, you decide you hate employer A and you want to move to employer B. Employer B will file an H1B. Employer B can get a 3-year approval. You'll have had 1 year with employer A, 3 years with employer B. That's a total of 4 years. You'll only have 2 years of H1B eligibility remaining. So it's 6 years of H1B eligibility, no matter how many employers you jump around to. A second issue with regard to transferring H1B. Crystal's going to talk in just a minute about the H1B quota and the H1B lottery. That quota only applies the very first time you get an H1B. Once you get your first H1B, you never have to worry about the quota ever again. You can change employers without worrying about the quota. You can apply for your second 3-year approval for H1B without worrying about the quota. The quota only applies the first time you get the H1B. Back to you, Crystal.
Yeah, the quota only applies that first time, but all of the other rules associated apply every single time that you apply.
Correct.
So we go with the cost. What the employer wants to know is about the cost. They have recently published a new fee schedule for U.S. Citizenship and Immigration Services. The fees have gone up. What you see on your screen are the new fees for H1B processing as of April the 1st of 2024. That means that if you're selected in the H1B lottery this year, these are the fees that we expect to apply to your situation this year, barring a lawsuit of some sort that stops it from going into effect. This is what we expect to be this year's fees. Big issue for employers, right? Employers are required to pay all of the fees that have to be paid for H1B petitions. So remember, we talked about optional practical training and the STEM extension. They don't have to pay for those. They don't have to file a petition for you. But once we get into the H1B arena, they're going to have to be responsible for sponsorship and the payment. That includes attorney fees and that includes all of the USCIS filing fees. Every year we hear stories about people who have been asked to reimburse an employer for these fees, or who have been asked to pay these fees directly. Important to understand that you are not allowed to pay these fees. So if you are in a situation where you are being told that you have to pay for the H1B, you probably need to discuss this with them. And if it's something where they're adamant about it, it may be a predatory situation. It may be a situation where you need to find a new employer. There are always scams going on in the newspaper trying to get people into a situation like this. You will never be asked to pay these fees. These are employer responsibility. The only fee on this screen that you could pay for is that optional premium processing fee at the bottom that you see. Normally, an H1B petition takes a couple of months to process, so 2 to 6 months to process, depending on the specific workload at the time. If you wanted your petition processed in 15 days, and it wasn't a business necessity, it was just a convenience for you, or you just really, really want the answer, you just really, really want to know, then that fee is something that you can pay. And that is a pretty steep fee, but it gets you a 15-day processing time for your H1B petition. All of these fees.
So let me say one quick thing about the cost of the H1B, because I can tell you that our office, in the time that I've been practicing immigration law, we probably processed 40,000 H1Bs. And I can probably count on one hand the number of employers who did not want to go forward with an H1B because of these costs. Employers are really not concerned about these costs. Most of them view the cost of an H1B like any other recruiting expense. They spend money sending recruiters to college campuses. They spend money on ads for candidates. All recruiting costs money, and most employers see these costs as just a recruiting expense, so it's not a concern. But it's very important for you to understand what these costs are, because some employers hear that it's $10,000, $15,000 to process an H1B. It's not. So it's important for you to be able to educate employers about what these costs are. And as Crystal said, there are basically two categories of cost. There's the attorney fee, which is our fee. Most companies don't process H1Bs in-house, so they hire an outside attorney. In our office, we charge $3,100, $3,100. Different lawyers charge different amounts, but that's what we charge. And then you look at the filing fees, and if you add all those up, you're looking at a little over $3,000 in filing fees, excluding the premium processing. So you're looking at a little over $6,000 to process an H1B. For most employers, that's a drop in the bucket and is not a concern. So don't be concerned about it, but you do need to know what those costs are.
And that they're not $10,000.
Or we're not charging enough, perhaps.
So as Mark said, we're going to move on to exactly when you can apply for an H1B. There are two classifications of two different types of employers when it comes to H1B. There are employers who are subject to the lottery system. They're subject to this H1B quota you see on your screen. And in a little bit, we'll talk about employers who are exempt from the H1B quota. The majority of employers are going to be subject to these H1B quotas. Every for-profit company that you work for is going to be subject to this quota. So that's why we start with this one, so that you can understand this part of the system. And then we'll talk to you about the discrete number of employers who are exempt from this system. So every year, the government has a fiscal year that runs from October 1st to September the 30th. Every year, they get a new replenishment of visas available. That's for your green card process. That's for your H1Bs. The numbers you see on your screen are your H1Bs. So every year on October 1st, a new batch of 85,000 H1Bs are available. Now, these are for people who have never been counted against the cap, never been entered in the lottery before. Remember, Mark told you that if you've been counted against the cap, if you've been entered in the lottery and won before, you don't have to worry about it. Those H1Bs, there are hundreds of thousands of those out there, and they're going to continue to be able to extend every year. But this is a new batch of 85,000 visas that's available every single year. The problem is there are more than 750,000 people who want them typically. So there's just a lot of entries for this lottery for this very discrete 85,000 number. So what they do is they separate this into two batches. They have 20,000 visas of this 85,000 that are reserved for people who have a U.S. advanced degree. So anything master's degree or higher, master's degree, doctorate, PhD, those are 20,000 of the visas are reserved for them, and then 65,000 for anybody with a bachelor's degree or people who have advanced degrees from anywhere around the world. Now, mind you that you can have a degree from anywhere and get your H1B from the US. It just has to be the equivalent of a US bachelor's degree or higher. So what they do is they enter everyone into the lottery. They take out all of the US advanced degree applicants. They pick 20,000. And then the people who were not selected go back into the batch and they pick another 65,000 plus applicants, because what they do is the same thing that they do in college admissions, right? They choose enough to try to make sure that they're going to have a yield of 85,000 on the first draw. So what you want to know is how many are available for the upcoming year. Well, we're in a good position because this year we're having this talk right before we start the lottery quota draw for this year. Every single year on October 1st, the new quota is released. In March, the beginning of March, is when all of the lottery entries are put in for the new H1B quota. So right now, what we're doing is the fiscal year 2025 lottery entries. Those are going to happen this year from March 6th to 22nd. So right now, everything is open. If you have an employer who wants to enter you or sponsor you, you can tell them that their entry point is March 6th to the 22nd of this year. So what's going to happen is that every employer has to create an account with My USCIS. That's where they'll enter your lottery information. The lottery selection is going to happen before April 1st. They typically select all of their entries, all of their entrants, the last 3 days of March, so that all of their entries are done before April 1st. At that point, your employer will have 90 days to actually file an H1B petition if you are selected in the lottery. So what we have up at the top of your screen is a continuum of the calendar. So what we're looking at is, let's say that you are in school right now, you're getting ready to graduate, you're a May graduate, and you want to be entered, you're going to start your OPT right after you graduate, but you'd really like to get a chance at the H1B lottery this year. What you would do is go ahead and talk to your employer. Your employer can enter you even before you've graduated, because they have 90 days after the selection on April 1st to file the actual petition. You just have to have graduated by the time that the H1B petition is filed. So if you're a May graduate and you already have an employer who really wants to enter you into the lottery, they can go ahead and do that this year, March 6th through 22nd. And then if you're selected, they'll still be able to enter your petition. They'll be able to submit your petition in the right period of time so that you'll get to enter this year. Now, if you are a May graduate and you're getting your OPT, but your employer isn't quite ready to sponsor you yet, and you want to talk to them about it for next year, then what you may want to consider is go ahead and get your graduation over with. Make sure you've filed your OPT application. As Mark said in the beginning, you want that to be good at the time that you graduate, or as soon as possible after you graduate, so that you can go ahead and start working. Let's pretend that you selected June 1st as your OPT start date. And so now you've got OPT for a year starting June 1st until next May the 30th. Around January of next year, that's when you're going to want to be thinking about really broaching the topic of H1B sponsorship with your employer, because you know that lottery entry period is going to be that same general time period every single year, that first couple of weeks of March. So January is the time when you really, really want to be talking to them, feeling them out, and seeing if they're going to consider sponsoring you for the following year. Because if that happens, what happens is they can enter you in that first couple of weeks of March. If you get selected before April the 1st, they're going to submit your petition within that 90 days. What you want them to do is you want them to submit that petition before your optional practical training ends, because at that point you would get what's called cap-gap protection. You would have protection from your employment authorization ending before that October 1st start date. So back on our calendar here, you have that OPT starting in June, lasting until May of the following year. They enter you in the lottery, March. They actually file your petition before the May 31st deadline of your OPT ending. And then the government automatically extends your optional practical training until October 1st, which is the start of the fiscal year when your H1B would normally start. So that's,
let me just emphasize a couple of things that Crystal has already explained, and that is this registration period for the H1B lottery. The registration period happens every year in March. We never know the dates for the registration until February of each year. So this year, it was only about a week ago that the government announced to the public when the registration period is taking place this year. So this year, the registration period for H1B is March 6th through March 22. Next year, it will be in March. It's always in March, but we don't know the dates until February. Once the government tells us when that registration period takes place, we start getting calls and emails from employers all over the country. Every employer that wants to sponsor an H1B has to file a registration during this registration period in March. Remember, the quota is 85,000. Last year, during the March registration period in 2023, the government received over 750,000 H1B registrations for the 85,000 quota. So what do? They put them all into a big pile. They first segregate out the 20,000 for advanced degrees, and we don't know how many advanced degree applications were put in. Let's say 200,000. They take 20,000 out of that pile. They take the remaining 180,000, they put it back into the big pile, mix it all up, and then they count out 65,000. Once they've counted out 20,000 advanced degree and 65,000 regular, that's the whole quota. You're notified by April 1 whether you were selected in the lottery. If you were selected, you then have 90 days to submit your H1B petition. If you were not selected, then you sit. And Crystal's going to get into what options may be available to you if you are not selected in this lottery process.
Yeah, so we've been talking about so if one thing to just step back for just a second is that your advanced degree is the same thing. If you haven't graduated yet, but you're getting an advanced degree in May, you can still be counted towards that advanced degree section. They can still enter you as an advanced degree holder. If you haven't gotten your undergraduate degree, but you're going to graduate in May, they can still count you as a bachelor's degree or higher so that you can be in the 65,000 number. We talked about this cap gap relief, and we're gonna hold on the other options until the end of the presentation. Those are going to be in that last slide. So we talked about that if you have your OPT before your employer sponsors you for this petition, then they're going to automatically extend your work authorization from the last date of your OPT all the way to September 30th, so that you'll have continuous work authorization until the new October 1st start date. So what we've just covered is cap subject employers. Those are the employers that are subject to the lottery, the ones who have to file in March in order to get a number for the fiscal year. They're the ones who are limited by 85,000. What we're going to move to right now is just talking about H1B cap exempt organizations. These are organizations that are statutorily not limited to that 85,000 number. That means that if you are employed by one of these organization types, they can apply for your H1B at any time of the year. They can apply for as many employees as they want. They don't have to be submitted at that time period. They can be submitted anytime, and they're not numerically limited in any way. But they are a distinct group of people. So what you see on your screen is the class of employers, who are cap exempt. So if they are a nonprofit university, so pretty much all of the universities that are nonprofit and accredited universities are going to be cap exempt. When we're talking about universities, we're not just talking about professors. We're talking about all of the different classes of people who are hired by universities. That's IT people, that's marketing people, that's administrative people and finance people, people whose jobs are professional positions that require degrees but aren't necessarily professors. Nonprofit organizations that are affiliated with universities are also exempt from the H1B lottery system. So when you think about this increases it even further. Any nonprofit organization that has an affiliation agreement with the university that is active and ongoing can be found to be not subject to the H-1B cap. So you're thinking about research organizations, you're thinking about hospitals, you're even thinking about school systems that have agreements with universities for, student teaching programs or other research programs, nonprofit research organizations that can be whether they're governmental or non-governmental organizations. Basically, what the employer does is they prove that they are designated by the IRS as a nonprofit, and then they prove that they fall into one of these categories. And at that point, that employer can sponsor any type of employee that they need to sponsor who's a professional that works in a job that requires a bachelor's degree or higher in a specific specialty, and they don't have to enter you into the lottery. Now, the question that we always get at this section is, well, what if I start working for a university and I want to transfer my H-1B to one of the for-profit companies? I'm working for Virginia Tech and now I want to move to Microsoft. It doesn't work that way because in order to transfer your H-1B to a cap subject employer, that cap subject employer would have to enter you into the H-1B lottery. Now, if you're working for a university and you get a part-time job offer with one of the cap subject entities, that entity can sponsor you, that employer can sponsor you to work at the same time as you're working for one of these cap exempt organizations. You can have concurrent employment with a second employer, but as soon as the cap exempt employment ended, so would the cap subject employment. You can only have concurrent employment with those organizations. To be able to transfer over to a different employer who's cap subject, you would need a lottery entry and selection and a petition filed by that employer. All right, so we've talked about all of the organizations that are subject to the cap and have to go through the lottery system. Every single one of those would have to get you a lottery entry in March and then file you a petition after being selected. And then we have these H-1B exempt organizations that are on the screen. What you'll be surprised to know is that this is actually a pretty broad group of employers. And this may be one of the places where your research about your employer and knowing about them might actually teach them something, because all of the universities know that they're cap exempt, but some of the other affiliated organizations don't realize that they could be using the H-1B program without the lottery. So you're doing research about your employer and finding out about what type of company you're going to be working for might help you figure out that your employer is exempt from the H-1B cap, and you can educate them and teach them about that. All right, so we've spent the bulk of our time on the H-1B program. If you're not able to find an H-1B cap exempt employer and you're not able to get a lottery selection, on your screen are some of the alternatives that are open to people who are not able to get an H-1B. So the very top line says that if you are a citizen of Canada, Mexico, Chile, Singapore, and Australia, there's actually an alternative to the H-1B that for each of these countries that is very, 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 very similar to what the H-1B program is. Canada and Mexico have a program that's under the TN classification, where there are a very, very long list of types of employment that would qualify for a TN visa, and there's no quota on those. Chile and Singapore have their own H-1B1 visa that follows the exact same rules as the H-1B visa, but it's limited to just citizens of Chile and Singapore, and so far they don't ever meet the cap for those H-1B1 visas. And then the Australian nationals, people with an Australian passport, are eligible for what's called an E3 visa, that is exactly like the H-1B visa, just without a quota. There are some little tiny legalese differences between the two. There are just some teeny tiny differences between it, but it's very similar. It has the same rules on what type of jobs qualify.
I know that Mary Ann wants to save a little bit of time at the end for questions. So let me just buzz through these other alternatives. So as Crystal said, the 5 countries at the top of the screen have great options other than the H-1B. The L1 is for individuals working for multinational companies. So if you get a job with a company that has operations outside the US and inside, you may be able to qualify for an L visa after working outside the US for at least 1 year. There is an E visa option for citizens of countries that have treaties of trade and commerce with the United States. You can actually Google E visa treaty countries and see if your country has a treaty of trade. The E visa may be an excellent option if you are from one of those countries. But with those exceptions, unless you're from one of the countries on the top of the screen, or you're working for a multinational, or you are from a treaty country, the options are extremely limited. And in fact, most individuals who are not selected in the lottery won't qualify for any of these others, and they just re-enroll in a degree program, or they return to their home country. And this is the part of these presentations that is always a little depressing for me, probably depressing for you, because the H1B really is the most important and the most common work visa for international grads of US universities. If you're not selected in the lottery, it can be extremely frustrating. But all we can really do is encourage international students to always plan ahead. And that is, when you're in the last semester of your degree program, plan ahead to get your OPT. While you're working using OPT, plan ahead to get the H1B registration filed during the March registration period. If you're selected in the lottery and your H1B is approved, then you can start planning ahead for permanent residence. And with that, I'm going to turn it over to questions.
Mark, I'm going to pop right into the conversation. This is Marianne. Incredible information. Get out your calendar. We are 3 weeks and counting away from that March window that only comes once a year if you're a group of those companies that must go through the lottery process. I want to bring attention to the fact that GoinGlobal, thanks to our affiliation with Mark and Crystal, in 1 week are hosting a special presentation for employers. That will be on Wednesday, February 21st. You register right through GoinGlobal at 3 o'clock Eastern again. So if you're in an OPT situation, or if you're in discussions with employers, or you're working with staff or faculty within your school who are really unclear on this process, a lot to wrap your arms around, please join us. You as well. The more informed you are as an applicant to drive the process and make sure these prospective employers have current, relevant, accurate information, the more you're going to be able to drive and fast track this process. Again, that's going to be on Wednesday, February 21st, 1 week from today, 3 o'clock, again, with our experts, Mark and Crystal. I'm going to start the questions off. I've got 2 quick questions for Mark and Crystal, and then we'll open it up to questions from the audience. Again, thanks to our affiliation with Mark and Crystal, you'll see their contact information. You are eligible as a GoinGlobal customer to be in direct contact with Mark and Crystal and forward any questions from you, or provide their contact information to employers you're interested in working with, or OPT employers, directly to Mark and Crystal. They'll be happy to answer. So Crystal or Mark, I've got 2 questions. My first one, can I, or an applicant, a student, just skip this entire H1B process and go directly to a green card?
Well, the answer to that is, in most circumstances, no. And the reason for that is there are only very few ways to get a permanent resident green card. The most common ways to get a green card are based either on family relationships or through an employer who sponsors you for permanent residence. If you have questions about family-based green cards, if you have a family member in the US who is either a US citizen or a permanent resident, That family member may be able to sponsor you if the family member who is a U.S. citizen or permanent resident is a parent, a spouse, a child, or in some cases, a brother and sister. So if you have a family member in one of those categories, you have questions about it, send me an email, give me a call. I'm happy to answer your questions. The other way to get a green card is through employment. And if you have an employer willing to sponsor you for a permanent resident green card, that employer has to go through a lengthy process. It's going to be a minimum of 2 years. If you're from China or India, it could be many, many, many more years than that to get a permanent resident green card. But the first step to getting an employment-based permanent resident green card, you have to have an employer. I've never known an employer to sponsor somebody for a green card before they went to work for them. And the way you go to work for the employer is through a temporary visa like your optional practical training or the H1B. There are certain categories of green card that you can actually sponsor yourself. One of them is called a national interest waiver. If the work that you are doing has significant national benefit, you may be able to qualify for a permanent resident green card based on a national interest waiver. Very few recent grads of U.S. universities are going to qualify for a national interest waiver. If you think you have a tremendous CV and you would like us to review it, we're happy to do so. We process many national interest waiver cases, and I can tell you in about 5 minutes whether I think you're going to qualify. So the short answer is green card is almost never an option before pursuing the temporary visa options available.
Okay. Wow. So the bottom line is H1B 3 weeks starting from now. That's your best track. Crystal, I have other questions, but I'm going to defer to the audience if you want to just answer a couple of questions. And then as a reminder to the audience, because again, you're affiliated with GoinGlobal, you can reach out to Mark and Crystal directly. But Crystal, why don't you answer a couple of questions while we have everybody online?
Yeah. So one of the questions that we got is, I heard that spring graduation is more beneficial than winter graduation for H1B, and they want to know why is that. And it's the timeline. The timeline is it's minorly more beneficial if you only have a single year of optional practical training, and that's because of that calendar that we looked at, right? If you graduate in December, then you're probably going to have your optional practical training from January to December of the following year. You're still going to have a full a year where you can apply for the lottery, right? Your January to January, but it's going to be at the very beginning of your job opportunity, right? So if you've started on January the 1st and you need to enter by March the 1st, that means that you'll have only been working for that employer for 2 or so months before they have to commit to filing this H1B petition. The second reason is because that cap gap protection doesn't help you quite as much, right? If you're entering in March and you have a December end date anyway, you're not going to get cap gap protection. In reality, you graduate when you graduate, right? You'll find a way to get some type of work authorization. You'll find a way to re-enroll. You'll find a way to close that gap between when your employment ends and when you can get your H1B. But there are a lot of people who feel like it's a little less beneficial to have a winter graduation. Another question that was on the chat was, can I be in CPT and apply for H1B? Yes, you don't have to be in OPT at the time. You can be maybe re-enrolled and doing curricular practical training is what the person asked. You could be outside the US completely. And your employer could sponsor you for H1B. You could have finished 3 years of OPT and STEM OPT and re-enrolled and suddenly found a job opportunity, re-enrolled in F1 status and suddenly found a job opportunity that you really wanted, and you're enrolled in school and not working for the employer, and they can still enter you in the H1B lottery for the year. They can enter you from any status that you're at. You just have to be, if you're in the US, you have to maintain some type of non-immigrant status. If you're outside the US, they can sponsor you clean for H1B. It would just be that once you got your H1B approval, you would process a visa at the US consulate and come to the US automatically in H1B status. Another question that's on here very frequently is the statistics for the selection rate. So there are 85,000 slots. Last year, there were 750,000 entries, but it turns out that a good proportion of those were actually people who had 2 or 3 entries for them. So this year, the Immigration Service published a new regulation, and the new regulation says that no matter how many times a person is entered by different employers, so let's say that you have one employer, but you have 2 other employers who would really like to hire you, so all 3 of those employers separately enter you in the H-1B lottery. This year, for the first time, the U.S. Immigration Service is going to consolidate all 3 of those entries into one entry for the individual. And that's going to mean that instead of those 750,000, where 300,000 of them had 1, 2, or 3 or 4 entries, now it's going to be reduced down. Those duplicate entries become 1. So the expectation is that this year there will be a statistically better chance for the individual to be selected, because even if you're entered 4 times, that only counts as 1 entry for you, which means that if you only had 1 employer sponsoring you last year, now you have an equal opportunity as the person who had 3 or 4. So the statistics are expected to change this year. Last year, it was 750,000, so you can calculate that, right? 85,000 out of 750,000 entries, the chances of being selected were much lower. They're really hoping that the odds will increase with this new system this year.
Let me emphasize one thing about multiple registrations. What Crystal was saying is that you as an individual can have multiple employers file a registration for you. Only 1 registration per employer. If an employer tries to file more than 1 registration for you to try to increase your odds, you will be found and they will reject all of your registrations. 1 registration per employer, but you can have multiple employers file a registration for you.
And that's an extremely important part of the new regulation. They will automatically throw out, if the same employer sponsors you more than once, they will throw out all of those entries. The second thing that they're doing this year to try to make sure that they catch that even better is that they're requiring that your employers put your name, date of birth, and your passport number onto your entry. And it's very, very important that if you have personally more than 1 employer sponsoring you, that you use that information is uniform throughout, because they are doing a lot of fraud detection this year. If they figure out that, let's say you have 2 or 3 different citizenships and you've put yourself in under 3 different citizenships trying to get 3 different entries, they have put into the regulation that they can rescind your H-1B after you've been selected and after you've been approved, once they detect that level of what they consider fraud, because it's you being entered more than once in a way that is used to game the system. So if you have more than 1 employer entering you, you must use the same name, the same date of birth, and the same passport ID for every single one of the employers who enter you. They are taking this extremely seriously, and the new regulation has been written to really try to catch as much of this as they can.
With that, Crystal, I'm going to cut off the questions. If my head was not detached from my body before, it is now. This is why we love Mark and Crystal. You're hearing about very new regulations and requirements from the U.S. government as they pertain to H-1Bs. I would speculate that there are thousands of potential employers out there who are not aware of this very critical new fraud detection policy from the U.S. government. The last thing you want is for an employer who has done this for decades in the past to do it again this year and not heighten your chances, but worsen your chances. So again, I want to remind you and any employer you're in contact with, please join Mark and Crystal next week, Wednesday, February 21st at 3 o'clock Eastern, to hear more about the employer side, this latest critical information. Remember, we're 3 weeks out of the gate. Next week, we are 2 weeks out of the gate with new regulations. So we're hoping that you will join Going Global, Mark and Crystal, Wednesday, February 21st. Also note that Mark and Crystal will be joining us on Thursday, March 14th on a whole different topic, OPT, CPT, and STEM extensions. And again, in April, Mark and Crystal will be joining us to talk about permanent resident green card processes. As Mark and Crystal said repeatedly, because of our affiliation, because of Going Global, you are welcome to reach out, have your employers reach out to them directly for more specifics and clarifications on the topics that they have discussed. I hope
Mark,
that you will go.
can you share the contact information too? Sorry to interrupt, Marianne. Crystal, can you move to the last slide? Thank you.
Oh, there we go.
Is it there?
Yep.
All right. Well, here, Mark and Crystal. And this is why Crystal told me today she gets 3,000 emails a day. I thought I had a lot in my inbox, but Crystal, you got me beat. We hope you will join. Going Global has so much information that complements the advice you've gotten today from Mark and Crystal. We have 16 million worldwide job and internship postings. We have H1B visa applications, a database of 6 million of them going back to the year 2009. So you can identify which employers have consistently, year after year after year, submitted H1B applications. We have information on OPT, how to work in 47 cities in the U.S. I'm assuming that everybody on this call would like to try to explore employment here within our borders. We've got city career guides and a whole lot more, and we have weekly training sessions so you can learn more about Going Global as well. So with that, I'm going to sign off. Mark and Crystal, you are as awesome as ever. We look forward to seeing you both next Wednesday, February 21st. On behalf of Going Global, Mark and Crystal of the McCandlish Holton Law Firm, thanks for your time this afternoon, and get to it. Goodbye.